and she has moved to suppress on the basis of sufficiency of the search warrant. Now, as I've said before, I believe the search warrant is essentially unattackable, but maybe there's something here. So let's sort of go through the legal principle that we need to sort of analyze this under as we're sort of trying to analyze this, and so we can understand what we're doing for. Okay, so to get a search warrant, you need to specify what you're looking for and where you're looking for it, and you need to have sufficient indicia that you can find that thing in that place. That's the goal, right? That's the specificity of a search warrant. We don't allow general warrants, which is we're just going to come into your house and look for stuff, right? We don't allow that. That's something the British did. We don't allow that. We need you to come to look for something specific. And then you say where you're going to look for it. You know, are you going to look for it in the house? Are you going to look for it in the guest house? Are you going to look for it in the garage? You know, where are you going to find the thing? And then you go search for the thing that you're looking for in that place. All right. So if we want to know if there's sufficiency, the way we would analyze that is by trying to determine whether or not there's enough indicia that the thing we're looking for can be found in this place. This is a search warrant for drugs in the house. So do we have enough information? Do we have enough indicia to say that we're going to find drugs in the house? That's what we're looking for. And again, if we're trying to determine what level of certainty we're looking for, you know, it's a very, very low standard. It's probable cause. It is relatively low. Where exactly that is, you know, different lawyers will disagree. I've said 1 out of 10. If you wanted to say 2 out of 10, I wouldn't quibble with you very much. But, you know, it's something in that ballpark. It's not a lot, as opposed to preponderance, which is 5.1, as opposed to beyond a reasonable doubt, which is like 9.5 to 9.9, right? So we're not looking for very much. We're looking for something like 1, maybe 2 out of 10. Not a whole lot. Great. So do we have 10 to 20% certainty based on the information that's available? Okay, so let's read this and see what Kayla has to offer to the picture. Fun times. All right. So to the Honorable Court, the state and their attorney. This matter came before the court for contested omnibus on October the 28th, 2024 at the Candido High County Courthouse in Wilmer, Minnesota. Shane Baker, Candido High County attorney, appeared for him anorexic, and Nick had begun losing weight. Nicholas had injection or track marks on his arm. Okay, relatively fair characterization. The application for a search warrant was silent on whether the unidentified reporter was a person known to law enforcement, which shouldn't really matter very much, but okay. The application for a search warrant was silent on whether the unidentified reporter was a reliable source, which only matters a little bit. People are presumed to be reliable unless there is like indicia to the contrary. So a general report is understood to be reliable. That isn't to say it's sufficient. There's a difference here between sufficiency and reliability. So a report from somebody is generally deemed to be reliable, but it may not be sufficient. Depends on what they're saying, specificity, and other information. Detective Pomplin indicated that he was personally familiar with controlled substances, that Nick needs to get help and help for his children because of substance, and there was a video where Nicholas had a white powdery substance on his nose. If we get into the issue of the video being watermarked again, I am going to lose my shit. On May the 21st of 2024, Nicholas put a video blog online that showed him drinking what appeared to be an alcoholic beverage, in which he appeared to be under the influence of controlled substance. I've seen the video. I think that's a reasonable characterization. During the video, Nicholas leaves to use the bathroom and returns with a white powdery substance on his nose. I think it's debatable, but, you know, that's a reasonable characterization. I'm not sure that I necessarily would have agreed with that in the naked abstract, but I think that's a reasonable thing to believe that you're observing. The deputies believed that Nicholas was under the influence of a central nervous system stimulant. The deputies believed Nicholas ingested the substance through his nasal cavity off screen. Well, if you believe it to be a powdery substance on his nose, then he ingested it through his nose would be a pretty reasonable conclusion. During the video, Nicholas appeared to struggle to read the screen, rambled, and slurred speech. Yeah. Very much so. There is no indication contained in the application for a search warrant as to what time the day of video is created, whether children were under Nicholas' care or if there were any other adults in the home caring for the children at the time when the video was created. I don't really know how those have anything to do with anything because he's not being charged with child neglect, or maybe, and I don't think she is either, unless they're going to correct me, because I know there was a debate over what she exactly was being charged with because there was a cross-reference in the charges to a different subsection, and I didn't really know why the cross-reference was there, but it seemed like they were being charged with the same thing, but maybe there was a difference. I know he was being charged merely with the fact that children were present at a place drugs were. In her charges, there was a difference in the sub-charges, or it was a cross-reference, which I didn't know why they put it there, but, fine. Detective Pomplin alleges that Nick had been the victim of swatting, and Kandiyohi County had responded to those calls. Probable cause requires only a probability or substantial chance of criminal activity, not actual showing. And again, what does that mean in terms of percentages? Different lawyers will agree and disagree on that. But probability or substantial chance does not mean more probable. It means a probability. It means a substantial chance. It means more than a trivial chance. It means more than a speculative chance, but not much more. So again, 1 out of 10, 2 out of 10 would be where I would put it on the scale. But I'm sure other lawyers would disagree. I'm trying to reduce linguistic concepts to a numerical score. But, that's what I say, but okay. Plus, it's drugs, which as a practical matter has a tendency of lowering it because drugs. So assuming it was higher in the first place, but drugs though, the war on drugs has not necessarily been kind to the Fourth Amendment. So, curb your enthusiasm, as they say on that one, when it comes to your Fourth Amendment protections a little bit. The task of the issuing judge charged with determining whether probable cause to search exists is to simply make a practical, common sense decision whether, given all the circumstances set forth in the affidavit, including veracity and basis of knowledge of persons supplying hearsay information, hearsay is available in a search warrant. Hearsay is fine, but then you have to question its credibility. So hearsay is not as good as a direct report, but it is permissible. So anyways, given all the circumstances, there's a fair probability that contraband or evidence will be found in a particular place. That's right. So what I've said before is kind of this same idea, right? What you do is you take everything together in combination. Everything together in combination. And so no particular piece of evidence needs to be dispositive. So no particular piece of evidence needs to be the smoking gun. That's certainly not required. And no particular piece of evidence needs to even necessarily be high quality unto itself. You can have a lot of low quality evidence if you have enough of it. So it's basically, do you have enough? Can you add enough numbers together to get to this relatively low threshold? So if your evidence is kind of shit, but you have a lot of it, then maybe that's enough. If you have 1 or 2 high quality pieces of evidence, maybe that's enough. And also things in between. So, all that kind of stuff. So that's sort of what we're reaching for. So that is the correct legal standard. And that's kind of what I've said before. So, yep. Let's see. The affidavit must be sufficiently detailed and include all evidence law enforcement has that supports probable cause to believe the items sought are at the location to be searched, and must describe with particularity the things to be seized. I don't think that's actually quite right. I don't think they do have to be sufficiently detailed, but I don't think it's true that it has to include all evidence law enforcement has that supports it. I don't think that's correct. Now, normally law enforcement probably would want to, because, having more is better than not having more. But the law only requires 2 things here. It requires the police tell the truth, and it requires them to have enough stuff to meet their standard, and it requires them to disclose any information they do have that would tend to show that it's not true. So they have to disclose anything they're aware of that would undermine or mitigate or suggest against their warrant. So they have to include all that stuff. I don't think it's necessarily true that they have to include everything that's favorable to them, though. I don't think they have to. They just have to have enough stuff, and the things they disclose has to be true. So I don't think that's quite right, but okay. Affidavits must not be conclusory. In other words, you can't just say it's true because it's true. You have to actually have reasons and facts and stuff. But should detail the underlying circumstances that support the affiant's belief that there's probable cause. Please tell us the reason that you believe that this is true to the level of certainty that we require. Why do you believe these things, officer? Please tell us. Please tell us enough things so that we believe it too. Let's move into the analysis as it applies to this situation. The information reported to law enforcement has no indicia of reliability. The information in the affidavit can come from a variety of sources, including eyewitness testimony, informants, or surveillance. However, for the warrant to be valid, the sources must be reliable. If an informant is used, the affidavit must usually demonstrate the informant has previously provided reliable information or other independent sources corroborate. That is typically true, right? It is typically true. So yeah, like, why do we have confidence in this person and what they're telling us? So like, yeah, their reliability in the past would be helpful. If they're bringing other things to the table other than their word would be helpful. Although incidentally, we might be able to get those things ourselves as the police. They don't necessarily need to bring it to us. We could go get it. So if, some guy says, I think, Tim is a drug dealer, I see him asking sketchy, and I see kind of people coming at all kinds of hours of the day, and, they seem to be doing drug deals. I'm pretty sure he's a drug dealer, right? Is that enough by itself? Probably not. But what might the police do? Well, the police might decide to conduct surveillance. They might conduct a sting. They might interview people. They might ask other neighbors what they've seen. They might try to get video cameras if there are any in the area, someone's Ring doorbell, who knows, right? But yes, why do we believe this guy? Or this guy has been a really reliable person in the past. He's come to us 5 times in the past and told us about drug deals. And every time he's come to us before, it's been pretty reliable. So he's probably reliable the 6th time too. That works too. Yes. That makes sense.